Yes.
My lords, before lunch I was describing some of the history up to the point at which discussions commenced in liaison committee, not a formal reference, but meetings at which Kajima attended and during which period Kajima agreed to carry out the remedial works. I just want to highlight as well that during this process the following three matters were the case. Firstly, that Kajima pursued proceedings against its own supply chain because its limitation issues differed from my clients, as indeed my clients differ somewhat from the trusts, which is one of the reasons we're here. But it commenced those proceedings. In those proceedings, it fully pleaded out the defects with the hospital. Secondly, that the standstill agreements, which were entered into, list the defects with the hospital. Your lordships don't need to turn to it unless you would like to, but a reference there is the supplemental bundle, page 204. And thirdly, of course, that Kajima was spending this time remedying the defects itself. And I mention these points to highlight that this is categorically not a case where the claim was commenced against limitation concerns, despite the claimant not really knowing what the case was about. It's recorded in the standstill agreements. The pleading that Kajima brought was a public document. Both parties knew precisely what the claim was about. So insofar as there's reliance on Steamship Mutual and references to the unattractiveness of artificially extending limitation periods in order to give time to understand what the case is about, that is not the situation we are in here. In fact, of course, this is not a case where there is any attempt to extend limitation at all. The whole point is that these proceedings were commenced within the contractual time frame that was required. That's a conclusion of some of the history as to what the parties did during that period of the standstill agreements. I'd now just briefly like to refresh on the reasons that the respondent gave contemporaneously for its actions. And this is some of the documents that you've already been taken to, but I would just like to highlight some of the most pertinent parts of the correspondence at the time. The first is in the supplemental bundle at tab 15. This was the first letter from Bevan Britton that you will recall was written in response to a letter from Addleshaw Goddard saying we don't intend to extend the standstill. And I will just repeat the points made at paragraph 4 and over the page at 5, that the concern of Bevan Britton was that the current standstill agreement would be terminating with the remedial works not completed, no admission of liability from Kajima, and CAP still facing the possibility of a claim from the trust. And I pause briefly there to note the point I made immediately before the lunch break, that of course it was Kajima who had asked to delay these negotiations until after remedial works were complete, and they were now saying that they would not extend the standstill even though they remained incomplete. But it's in those circumstances that Bevan Britton explains at paragraph 5 that it will have to commence proceedings if there is no extension, it being acutely aware of the potential limitation issue that was due to arise in due course. How could it not be when it had entered into 4 standstill agreements? My lords, the next letter I'd like to take you to is at tab 17. Again, you have already been taken to this, but I would repeat at points 9 and 10 that Bevan Britton was again repeating the desire to extend the standstill agreement, the reasons being that it needed to meet with the trust before useful settlement discussions could be carried out. And that was very clearly its position. We want to have discussions, but until the trust is willing to meet and discuss its claim, we don't think that can sensibly be carried out. Now, Mr. Hargreaves, when we paused on this letter, pointed out at paragraph 5. He said, well, paragraph 5 shows that in fact you did know what the quantum of the claim was, because it was stated to be in the 5th bullet point, circa 21 million. Well, I'd just like to compare that, if I may, and I'd note at the start of paragraph 5, you'll see that that was the position of the trust at the end of 2019. In other words, there was not an updated position known in the 2 years since that, during which substantial remedial works had been carried out. I'd just like to compare that to the pleaded case, which is in the core bundle, tab 8, page 90. And in particular, at 53.4, you'll see that in terms of a pleaded case, our view was that the best that could be said at that time, somewhat later, was that the trust had indicated total deductions would be a little under 14 million if the remedial works had completed by the 30th of September 2020. They in fact completed substantially later than this. It's assumed that the trust claim may be greater than the sum referred to above. And then over the page 54, the basis for this calculation has not been set out by the trust, and it is CAP's position that its true liability is lower than that, so asserted by the trust. Now, needless to say, that was our pleaded position, because that is what we understood 2 years later, based upon matters that had happened since, to be our best guess as to the liability. But the reality was that we hadn't seen any calculations either way.
Not sure I understand that. The pleading says the trust had indicated that the total deductions would be a little under 14 million if the remedial works had completed by 30th of September 2020.
Yes. But they did not complete by that date. In fact, they completed in, I think, March 2022. So effectively, our pleaded position was we've got an indication which is clearly very out of date. We assume it will be more, but we don't know quite what. And we actually, we've never seen a calculation, and we think it should be much lower. But we say that the reason I raise this point, and perhaps if I explain the reason for it, it may assist. The reason I raise this is we say this is whilst one could theoretically make a technical referral to a liaison committee faced with this uncertainty as to quantum, it would not be an effective and useful one when we have seen no recent calculation from the trust as to what their claim is actually going to be.
But your letter does set out a calculation. It seems to be based on what they say was the position up until the 23rd of September 2019, and then a fixed monthly accrual which would be the same for every month thereafter until completion. And that's on that basis you calculated the figure to a date shortly after the letter. Well, would be 21.4 million, and that's not inconsistent with 53.4.
Perhaps I can put it this way. We didn't feel safe enough in that extrapolation of the trust's claim to put it in a particulars of claim with a statement of truth attached to it. So whilst we had put it in a letter, our pleaded position was somewhat vaguer because we were not certain as to the trust's true position and had not seen any calculation as to what it was now saying. And certainly, although there is a calculation here, the real question mark underlying the calculation is in fact how you get to the number of service failure points that are alleged, because that's what turns into money. And that's the real part that we didn't understand. But certainly, insofar as Mr. Hargreaves has suggested that this part of that letter shows that we knew enough about quantum to make a sensible referral, we say not. Our true position is that stated in the particulars of claim, which is that we've had some indications We don't agree with them. And we were waiting at that time for the trust to provide some clarity as to what its claim truly was going to be.
Can you just help me with this? That's all on the basis that what you're referring is a dispute between you and the trust. But what if the parties are you and Kajima, contrary to Mr. Hargreaves' submissions, but assume for the moment the parties are you and Kajima. The dispute is between you and Kajima. So what you would be referring to the liaison committee on this basis would simply be your claim for an indemnity from Kajima for anything that you're found liable to the trust.
Yes, and one could refer...
So does the quantum really matter?
Well, it does. We'll turn in a moment to how the liaison committee process actually plays out and what it produces at the end of it and whether it's of any use. But in the ordinary run of events, in my submission, if you are looking to talk to another party and try to settle a dispute, in my submission, you normally want to know the money that is said to be being claimed as a result of that dispute. And that parties merely talking about liability, of course, they talked about liability in the following sense. They had been invited to, Kajima had been invited to liaison committee meetings. They had attended those meetings. They had agreed to carry out remedial work, but it was on a without prejudice basis, where with no admission as to liability, it wasn't clear what was to be gained by formally trying to invoke a step which raised merely the question of are you liable or not, without actually bringing the question of money into it, because we knew where they stood on liability. They were willing to do the remedial works, but they weren't willing to make an open admission as to their legal liability for anything.
So there was a dispute at that stage as to whether they were liable to indemnify at all.
Yes.
And that's a dispute which could have been referred to the liaison committee and could have been the subject matter of proceedings without seeking any monetary amount.
Yes, it could have been. Whether it could have been effectively, whether it would have been a useful process. Is another question. In my submission it wouldn't, but we'll come to that issue in due course. I could just briefly pause to check something that the judge may have said when she addressed the question of whether a referral had actually occurred in her judgment. No, I'll move on. So we were looking at the document at tab 17, I believe. We could move on to the document at tab 19, just to highlight again. This is after proceedings have been commenced. And just highlighting on page 292, after they've been commenced, but before this application is made, it is the proposal of the claimant, CAP, that those proceedings ought to be paused by one mechanism or another in order to give time for the parties to go through the liaison committee process. And one sees effectively the same point made again at the letter at tab 20, page 294, over the page on 294, the two paragraphs beneath subparagraph B on 294. So we say this is, and of course what then happened was that a stay was applied for, and it effectively crossed in the post with the application to set aside the claim form. They were both made on the same day. I don't think there's any suggestion that one was a response to another because of the preparation time that would have been needed for both. And the reason I take you to these two letters, various letters, is really twofold. First of all, to show that this is a party who was acutely aware of the limitation deadlines, was never going to let those pass. Secondly, that CAP was not a party seeking to avoid alternative dispute resolution. It was a party seeking to engage in it at a time when it would be useful, namely when it had had engagement from the trust and clarity as to what the trust's claim was going to be. This was a TCC claim, and CAP was following the approach advocated in the pre-action protocol for construction and engineering disputes. If, for limitation reasons, you can't comply with the protocol prior to issuing proceedings, which is that you issue those proceedings and then you stay them in order to comply with the protocol after issue. Now, this is, of course, not an application about the protocol. It's an application about a contractual ADR procedure. But in my submission, one question for the court to consider today is the difference between the two so extreme that conduct encouraged by the protocol should, in a contractual context, be viewed as so extreme as to lead to the claim being barred? And we say not.
Was there any explanation in the evidence about why the referral to the liaison committee didn't, in fact, come until mid-March, over two months after the last letter we saw? And had the claim been finalised, had the trust's claim been finalised by the time of referral on the 18th of March?
If you can bear with me to ascertain the dates. The date of the particular claim is early April, 6th of April. So I think it's certainly right to say it would have been substantially underway by the date of that referral, the drafting of the particulars of claim, if that's was that your lordship's question?
No, my question really was, we've seen the correspondence in December and January, and the December correspondence recognising that there will be a need to refer on your side, but the referral doesn't actually come until the 18th of March. I'm just wondering whether there's an explanation for that, and in particular whether the trust had quantified its claim by that stage. I don't think it had, if one goes by reference to the particulars of claim, so that can't be the explanation for delaying.
If I may briefly turn around, I think. I think there are two factors at play here. One is that having made an application for a stay in order to comply with that process and a looming court date, I think it was felt that even though there was no better information available yet, having asserted to the court that that was what the stay was to be used for, it was felt that it would have to be done. And as to why it happened then rather than a month or two earlier, my understanding is that was to do with trust availability. That's what my instructions are just now. The trust availability as to when they were willing and able to have a meeting. My lords, I said before lunch that I would set out some of the legal structure in my introduction, but Just to make clear that my signposting has changed a little bit. It was all to do with ground 3, so I'm going to pick those points up at the start of ground 3 instead. So my introduction won't tackle any legal points. I'm going to move straight on to ground 1 now, having set out some of the background. Ground 1, in short, is, are the dispute resolution provisions in this contract, is the liaison committee process enforceable? I'm going to address this under 3 topics. The first is to consider the legal principles that apply. The second, to look at the contractual provisions. And the third, to look at the judge's decision and explain why, in terms of commencement, process and outcome, the contractual provisions are not sufficiently certain. Starting with the legal principles, I address these in my skeleton argument at paragraph 16. That should be in the core bundle at tab 16, page 171. That's core bundle, tab 16, page 171. My lords, I refer there in paragraph 15 to 2 cases, 2 first instance cases only, of course, Holloway and Chancery Mead and Tang and Grant Thornton. And I refer there to specific paragraphs, both of which set out the judge's view of what the requirements would be of an enforceable dispute resolution process. The 2 overlap, and I've set out at paragraph 16 my submission as to broadly what the effect of the 2 taken together is in my submission, which is that the process for commencing the ADR must be sufficiently certain, and that this means each party knows what steps they're required to take to commence the process. The administrative process for selecting the party to resolve the dispute is defined, and there should be no need for further agreement before matters can proceed. And the process to be followed once the ADR has been commenced must also be sufficiently certain, so that the parties know what participation is required of them, and the parties know when the process will be exhausted or properly terminable. Now, in this case, and we'll turn to the judgment to look at it in a moment, the judge also looked at factors relevant to the outcome of the process. And we say that she was right to do so. And if that is in any way an extension of Holloway or Tang, then it's a correct extension. That one looks at all steps of the process: commencement, procedure itself, and then the outcome, and they all need to be certain. And the need for certainty in all 3 steps is particularly acute in my submission, and particularly highlighted by a case such as this, where it is being said that the proceedings are susceptible to strikeout if there is non-compliance. And insofar as the cases of Holloway and Tang impose requirements that perhaps appear stricter than some of the more general statements made by the courts about striving to enforce and give effect to a party's bargain. The one reason for that is that they are steps purporting to limit and control a party's access to court. That is an important general right, but obviously it can become particularly acutely important when up against limitation. And therefore it is right that those cases demand clarity from any process that is to be a hurdle in the way of starting court proceedings. Parties are entitled to know whether they are in a position where they are entitled to start court proceedings or not. And we say that explains the rules laid down in Holloway and Tang.
Those were both cases, I think, which contemplated that the condition was the completion of the process. Does it follow from what you've just been submitting that if you had a clause in which the condition was merely the commencement of the process, that it would only be the certainty as to what should happen to commence the process, which would be critical?
I think that is right. Although if I may just pause on that and note the following. The way in which the matter is approached in Holloway and Tang, and in my submission, the correct matter, the correct respect is to look at the procedure as a whole and take the view, is this procedure an enforceable procedure? So whilst it is right that from the problem I just alluded to of certainty as to when you might start legal proceedings would be solved, from a legal perspective, it may be that the process as a whole stands or falls with the certainty of that process. And if at some point it falls apart because although you know how to start it, you don't know what happens thereafter, then in my submission, the whole process then becomes null and unenforceable. It isn't the case that just because you're told clearly how to start it, and just because your right to go to litigation is purely conditional upon it being started, it may nevertheless be that that procedure is unenforceable because of what happens after commencement being so vague.
Well, you may not be able to enforce it because it's sufficiently uncertain in the post-commencement process, but why should that in any way invalidate a condition precedent if the condition precedent is you must start?
In my submission, because one looks at the contract and asks whether the totality of the process is one that is clear and enforceable enough, and that the courts, in my opinion, correctly, would not require a party to start a process and would not uphold a term of a contract that required a party to start a process, the continuation or outcome of which was uncertain in effect, that the courts would recognise that it is a consolidated whole, effectively, that stands or falls as one.
I wonder how that sits with what Lord Justice Morbick said in the Sulameric case. We haven't got that in our bundles, I don't think.
No, I forget. I think was it Tang that it was referred to in?
Yes, and the judge referred to it. But first of all, Lord Justice Morbick seemed not very keen on the sort of formulations we've got in the first instance cases of the requirements as to certainty, which may be something we'll have to consider. But he also, I think, referred to an alternative submission on the part of Lord Wolfson in that case, that it didn't matter if there was uncertainty as to the later stages of the process. It was at least clear in relation to commencement, and dealt with it on the basis that in that case the commencement process wasn't sufficiently certain. I didn't say in terms,
I understand.
It would have been if it had, but he, as I recall, didn't really seem to approach it, that alternative submission, on the basis that if all you've got is sufficient certainty to start, that won't do anyway.
And it may be possibly that when one gets to the question of discretion, it all gets wrapped up in utility in any event, because the need to commence a process which ultimately goes nowhere because the procedure itself is so vague as to be unenforceable.
Well, if there's uncertainty as to what the obligations are, so that it's difficult to enforce it, that's one thing, but that doesn't mean it has no utility. It may be that it will run its course perfectly sensibly and serve its purpose.
Well, that is correct. In my submission, though, obviously I'm in a degree of difficulty because the Morbit case is not in the bundle, and
No.
I'm not as familiar with it as I believe your lordship is. In my submission, what one gets, at least from Tang and Holloway, is in fact to be viewing the procedure as a whole, to be saying, in order for an ADR procedure to be enforceable, it needs to tick the following boxes. In my submission, from a matter of practicality, that is correct. That these parties, from a commercial common sense perspective, are not imposing these requirements in the contract in order to try to set traps for the unwary. They're imposing these procedures into their contract because they're meant to serve a purpose if they've been properly and sensibly drafted. And in my submission, from a commercial common sense perspective, if the second half of a procedure falls apart and falls away, I would query whether it doesn't take the first half of that procedure with it, and insofar as any term of the contract purports to make that first half of the procedure a condition precedent, then if it's now recognised that that procedure is unenforceable, the condition precedent would also effectively go. But I'll also be coming to the question of whether commencement is actually the condition precedent in this case, because in my submission it in fact isn't because of clause 7 of Schedule 26, but I'll come to that in a moment. If I may, though, I've got the case of Tang in front of me, and if I could ask your lordships to turn to it. This is in the authorities bundle at tab 11. Now, this was a case that involved a network of accountancy and audit firms, sort of all operating under a single international umbrella entity, and the contracts governing their relationship provided that if partners were expelled from that network, there were certain dispute resolution procedures which could be enacted. The relevant one in this case is set out in the headnote. Could I ask your lordships to read that? In the headnote, if one looks at E in the margin, just below it, there's a reference to clause 14.3, provided that any dispute. And if I could ask you to read that down to about line H, just to see what Tang involved. So, in short, it involved a two-stage process. The first was a referral to a chief executive, and the second was a referral to a board of a panel of members of the board with no great amount of detail as to what each was to entail. And in that respect, it arguably mirrors this case in terms of sparsity of information. If I could ask you to turn to page 1240 of the judgment. One sees at paragraph 63 some of the queries that were raised about this. And it says at the first stage, all that's required is a reference to the chief executive. That seems a clear requirement. But then at point 2 on line 4, however, no more is said in section 40.3b. as to what form the process of conciliation should take, nor Roman numeral 2, who is to be involved in it, and what they are required to do by way of participation in the process, nor indeed, as at 3 Roman numeral 3, what the obligation to attempt to resolve the dispute or difference requires the chief executive to do. And then 3, in relation to the next stage of reference to the panel, again, no more is said as to what the process or form of resolution should be, nor whether it is to include participation by the parties to do the dispute, nor Roman numeral 3, what will suffice in terms of an attempt to resolve the dispute, whether on the part of the panel or on the part of the parties, etc. And I flag that up because in my submission, those are all queries that could readily and properly apply in this case. And I just highlight, insofar as there's any doubt, that on page 1241 of the judgment, paragraph 72, at the bottom of the page, there's a line that starts in particular. Sorry, a sentence starting in particular, bottom line. In particular, I accept the omission to give any guidance as to the quality or nature of the attempts to be made to resolve a dispute or difference renders the court unable to determine or direct compliance with the provisions of those sections. So, insofar as there's any doubt as to whether it's that was the basis of the decision in my submission, it was. And in my submission, this is a correct and sensible example similar to this, where the court has looked at a dispute resolution process and gone, there's not sufficient certainty as to what to make of this. My lords, those are my submissions on the legal framework to apply. I'll now turn to the terms of the contract, and I'll start, if I may, with the project agreement, because as you'll be aware, the liaison committee is actually introduced and its role best described in the project agreement. And this is in the supplemental bundle at tab 1, page 28. I'll just highlight the points that several of which you're aware of, but just to add in places some extra submissions. As you're aware, the liaison committee this is 12.1, is made up of 3 representatives of the trust, 3 representatives of Project Co. There is no submission made by Kajima that this is in any way changed when the liaison committee is referred to in the construction contract. This is the makeup of the liaison committee, which is referred to in both the construction contract and the project agreement. And as has been noted at 12.2c, there is a reference that the function of the committee is to provide a means of resolving disputes or disagreements between the parties amicably. Now, where that is a dispute between the trust and Project Co, who are the members of that committee, it's relatively clear how that takes effect. In my submission, somewhat less clear how that takes effect where the dispute is between Project Co and Kajima, Kajima being a party who is not a member of the committee and nor has any automatic right to attend or be heard, and certainly not to vote. At 12.3, it says the role of the liaison committee is to make recommendations to the parties, which they may accept or reject at their complete discretion. I pause briefly to note that, as you will have seen in Schedule 26, there is a somewhat conflicting reference to it being final and binding, subject to the agreement of the parties. I'll come in due course to what I say that means, but I just note at the moment that apparent discrepancy. 12.5 gives the general right to the members of the committee to adopt such procedures and practices for the conduct of their activities as they consider appropriate. 12.6 is potentially relevant because it effectively requires unanimity before any decision can be taken, and that unanimity must include at least one member of the trust and one member of Project Co. So you can effectively be sure that any recommendation the committee makes will have the blessing of CAP and be an outcome that it is happy with, since it can never be outvoted. It always has to have at least one representative, and the decisions must always be unanimous.
Well, it be happy with it in the sense of the members of the liaison committee being happy with it.
Yes.
It's a separate question.
There may be
as to whether the legal entity as a whole will be happy with the stance taken by those on the liaison committee.
I accept there is the theoretical possibility. In my submission, liaison committees will often be staffed by relatively senior members of the companies involved, particularly where the company is, as here, a special purpose vehicle. And therefore, whilst it is certainly conceivable in my submission, it would be unlikely, but I accept the theoretical possibility.
Certainly on the trust side, that might not be the case.
Yes, my submissions are going to be based more upon the partisan nature of the committee vis-à-vis a dispute between Kajima and CAP, where the trust position may be less important. At 12.10, we've seen the provision about meetings of liaison committee being convened at not less than 10 business days' notice, and my Lord Justice Popplewell anticipated the point, of course, that it also says in Schedule 26 that construction disputes should be thought to be resolved within 10 days. So unless one defines every construction dispute as an emergency, which in my submission would be a somewhat difficult contention, it's not entirely clear how those two are meant to relate to one another.
Unless the telephone option bites.
My Lord, did you say the telephone option?
Yes, 12.11. Does that still have the 10-day?
I had understood 12.11 was about how you would conduct a meeting once it had been arranged, but it did not affect the date upon which it should be arranged, which was set out by 12.10.
Can you assist at all, Mr. Webb, with my inquiry this morning about the definition of construction dispute?
Yes, I can. It is defined in the main contract it's at tab 2, page 67.
Thank you.
And for your Lordship's benefit, the Housing Grants Construction and Regeneration Act is an act which broadly applies to all domestic construction contracts. There are exclusions for certain lines of work, such as in a lot of work in the energy sector or similar. But the breadth of the Housing Grants Construction and Regeneration Act is very broad within the sphere of the construction sector. And therefore, just to highlight that caveat attached to the end of construction dispute is not, in fact, that much of a narrowing caveat.
Yeah, thank you.
But that's not repeated in the definitions that are specifically identified for the purposes of the construction agreement in Schedule 1.
My understanding, and I believe there is a general provision to this effect, is that the construction contract states that any term not defined in the construction contracts is to take its definition from the project agreement. And I did look earlier and I could not see construction dispute defined in the construction contract.
But there's a general incorporation of definitions insofar as not set.
I recall having seen one. I suspect it is probably...
I'm sure someone behind you will find
Yes.
it while you're continuing.
Yes. My Lords, having gone through clause 12 of the project agreement, I'd pause there briefly to say, whilst there are undoubtedly uncertainties as to how it's meant to work under the project agreement. And we would say that those uncertainties are in fact sufficient to render it unenforceable. But that's not a central question for today. But we do say one can at least see on its face how it is intended to work under the project agreement. Because it is effectively a form of a negotiation provision. Senior individuals from each party are meant to meet and try to resolve their disputes by agreement. The difficulty comes with trying to one of the difficulties, I'll come to others, but one of the key difficulties comes in trying to transpose that perfectly sensible arrangement into the construction contract, because of course that immediately removes it from the realm of being a dispute resolution process involving amicable discussions between the two parties to the dispute, because the members of the committee are no longer the parties to the dispute. You have been...
So why did CAP incorporate it?
Well, I don't think
one of
anybody
the
knows.
oddities is, unlike some of the reported authorities, it's the party, as it were, in the middle, in this case, who is saying it's unenforceable, as opposed to the party on the far end. So I understand your submission, but we have to remind ourselves that it's CAP who made Schedule 26 part of the construction contract in the first place.
That's of course right. Well, these are complicated suites of contracts that are normally negotiated at the same time. You normally execute the project agreement and
which nobody ever reads.
Well, they are very...
Lawyers make a lot of money drafting this rubbish and nobody ever reads them.
They are very substantial, and...
They are very substantial, that is certainly right.
I think it's difficult to resist the conclusion that something has gone wrong in the way in which this process has been incorporated into the contract. The question for your lordships is whether it has rendered it unenforceable.
Yeah.
But in my submission, it's difficult to resist the conclusion that something has gone wrong. I can't recall if your lordships were taken to it, but clause 12 of the construction contract, at the supplemental bundle, page 135, as regards the liaison committee, it's been included, but as you'll see...
Sorry, supplemental bundle, page...
135, tab 4.
Yeah.
So there's a clause dealing with it, as there is in the project agreement, but in actual fact what they've done is left a lot of not used, and just included a general obligation at the top to provide assistance in the performance by Project Co of its obligations under the project agreement in respect of works-related matters considered by the liaison committee. So effectively a sort of cooperation or assistance obligation. They've not turned their minds to how the liaison committee actually works to resolve disputes within the construction contract, meaning that effectively all we are left with to try to resolve that question is the relatively meagre wording in Schedule 26 and how that relates to Clause 12 of the project agreement that we've just looked through.
I confess, and I'm sure I'm only speaking with myself, I had not looked at page 135. So just help to orientate me, will you? This is the construction contract.
This is the construction contract.
This is clause 12, mirroring the numbering in the project agreement.
Yes.
Not on page 28 we've got them. Clause 12 on 12.1 is the same numbering but different wording. 2 to 11 not used, and then no 12. Is that right?
And just to, I haven't been through the whole contract to confirm the extent to which this is the case, but just to give an idea of how these things are negotiated back to back. Clause 13 is disaster plan in both contracts, and clause 11 is representatives in both contracts, albeit, for example, with representatives, there do appear to have been changes so that it's now describing the representatives of Project Co and the contractor in the one contract, as against the trust and Project Co in the other. But
does this not suggest that somebody looked at, contrary to my rather dismissive comment earlier, somebody looked at this and decided those paragraphs were not relevant?
Well, it either, yes, but I suppose the question that arises is that have they decided they're not relevant because they've decided that they are incorporated through the definition of liaison committee? Or have they decided they're not relevant because they are not meant to apply?
I see what you mean. Yeah, okay, that's a fair point.
What they certainly haven't done, but in my submission to give rise to an effective form of dispute resolution should have done, is wrestled with the question of how the liaison committee makeup or process might need to change in order to be an effective form of dispute resolution under the construction contract. This is where you'd expect them to do that, and this is where they haven't done it. So, as I say, when it comes to interpreting the construction contract, we are effectively left with those two brief clauses in Schedule 26, which I'll be turning to in a moment, the ones that talk about things being final and binding and seeking to reach a decision within 10 days. And by virtue of the definition of liaison committee, clause 12 of the project agreement, which we just went to, and that's pretty much the source of the contractual information we have to work out what this process is meant to involve and consist of. I said at the start of this ground that the third rung of my submissions on the topic would be to turn to the judgment.
So are you going to come back to what you say, the final and binding?
I'll be looking at what the judge has said and seeking to explain why it's correct by reference to turning to the contract at that stage. So I'm briefly just taking a detour to see what the judge said on the point. It's in the core bundle, tab 5, page 53. And here the judge gave 5 numbered points that she relied upon to support her view that the dispute resolution process in the contract was not enforceable. And in my submission, they break down into the 3 categories I referred to earlier, relating to either commencement, process thereafter, or outcome. And I'm going to start by referring to the judge's conclusions on the outcome. And I'm going to just preface these submissions with the following point. We say that the following matters go to enforceability. If the outcome of a process is unclear or not recognised by the court, then we say the process as a whole falls away and is unenforceable. However, if that is wrong, and referring to a point that my Lord Justice Coulson made earlier, if that is wrong, then everything I say is in any event in my submission relevant to the utility of the process, which itself is directly relevant to the court's exercise of discretion. So I say this does go to ground 1, but if you're not with me on that, I say at the very least it goes to ground 3. And the 2 points where the judge addresses outcome within paragraph 61 as to her reasons for finding it not to be enforceable are Roman numeral 2 and Roman numeral 4. And what she says at Roman numeral 2, is that in circumstances where Kajima is not obliged to take part in the process and has no right to do so, it is impossible to see how the process can be said to provide a means of, and this is in bold, resolving disputes or disagreements between the parties, again in bold, amicably. And she says a few lines down from that, I cannot see how it is possible to resolve a dispute between 2 parties amicably when one is not involved in the process. I'd submit that's entirely correct, and I'll come to why in a moment. And then the other is at point 4.
Which means can't be compelled to be involved in the process.
Can't be compelled to be, and in my submission, has no voting rights in the outcome of the process.
Well, that assumes that the outcome is going to bind it.
It at the very least assumes that the outcome is intended to be a recommendation, and in my submission that is the anticipated outcome of a reference to the committee. Whether or not it binds it, if there is a recommendation or decision taken by 1 or 2 entities as to how a dispute should be resolved, but one of the parties to the dispute is not an entity making the decision, then it isn't an amicable resolution of the dispute. It may be a form of resolution, but it's not been negotiated to be an outcome that both parties are happy with. It is a proposedly imposed outcome. And in my submission, I would draw that distinction that ordinarily an amicable settlement is one that's accepted by both parties rather than imposed by, say, an arbitrator or an adjudicator or some other.
Yes, like mediation.
Yes, like mediation. And in my submission, that's central to what's being said here, which is that an amicable process involves an agreement of both parties. But in fact, what liaison committee process spells out is a decision being taken by 3 members of the trust and 3 members of Project Co, but no one for Kajima.
Yes, but unless as a matter of construction, that decision is binding on Kajima, which will see, I'm interested to hear what you've got to say about that. But unless that is the case, then it is just a form of mediation, isn't it?
Well, but in my submission, it's not even that, because they're not involved in agreeing it. So it falls away because it's neither agreed nor a third party's decision that's imposed. It seems it's almost a thing written in sand. It's just someone opining what they think the outcome is that has no status and isn't agreed by the other side. Maybe that is what the parties contracted to do, just to have somebody say out loud, I think the answer is this, but it's of no bearing on anyone. But we would say that would be an odd decision. Nor most.
That's what happens in mediation. You ask the mediator to help you agree, and if you don't agree, you don't agree. And the mediator can, depending on how good they are at the job, express views or not express views. That's what mediation's all about.
That's true. The difficulty here is that the person occupying the role of mediator is deeply partisan, and that's one of the reasons it's not an effective process. Is because we are being asked, we're being judged on our own case, so to speak.
Well, I must be careful not to try and construe the whole thing by reference to the particular dispute with which we're concerned, but in a back-to-back dispute, the CAP members may not be partisan at all, subject to questions of solvency. The ultimate dispute is between Kajima and the trust.
Yes, and it obviously depends how the dispute is framed as to, they probably they would be partisan on the principle of if there is liability, should it be passed on, but they may not be partisan on the question of whether there is that liability in the first place. But I'll jump to point 4 and then move into the heart of it, which is what the contract says about the effect of it. Which is, point 4 is it's unclear what impact any decision of the liaison committee has on Kajima. And this is the final and binding point, and what it means, and if there's any clarity on it. And we say that the judge was right on both those points. And I'll take that in 2 stages. One is, what is this alternative dispute resolution process that we're talking about? What's its effect? What does it produce? To some extent, the points that we've just been talking about. And the second is, what is the effect of any decision reached? And on the first of those questions, going back to what I said a moment ago, in my submission, this process does fall between 2 stools. It is not a form of amicable dispute resolution between 2 parties who are trying to negotiate their problems. It isn't a process which involves a third-party decision telling the parties what the right outcome is. It isn't like an arbitration or adjudication or even an early neutral evaluation, which may not be binding, but at least serves a purpose because it is a neutral third party coming to give a guide as to what they think the outcome is. This is a process which, in my submission, does involve a highly partisan committee passing judgment on the dispute. Certainly, in terms of this dispute, it would be a partisan committee. And we say that that would render the outcome of any of the process effectively unenforceable. And I provide an authority referred to in my skeleton. I won't take your lordships to it because I think the principle it stands for is relatively simple. Shorter and Nile, and it stands for the proposition that an expert determination process will be void for actual bias. If the expert determining the dispute is actually biased, it will be void. And I refer to that because expert determination is, in my submissions, towards the sort of Wild West end of dispute resolution, by which I mean there are no rules of natural justice that are inferred into it.
That's sorry to interrupt you. That's
yes.
all on the premise that what is happening is a decision which is imposed on Kajima.
Yes.
Which isn't your case, and I think is not Mr. Hargreaves' case, if I understood it right, as to the outcome of the process.
If it were an enforceable process, then no, in my submission, it is the outcome of the process is a decision that is imposed on Kajima.
It is, so that if the committee decides, contrary to Kajima's submissions, that the answer is X, that is final and binding on Kajima, is it?
Yes, because again, it's...
And how is that, sorry to interrupt you, how is that then performing the function of resolving the dispute amicably?
Well, in my submission, it isn't.
No, so it can't be. If the liaison committee can only do that which it is given the powers and functions to do under clause 12C, and it can only, therefore, seek to reach a decision which is by way of recommendation or is not in fact binding, because anything else would not be resolving the dispute amicably between the parties.
And yet, Schedule 26 of the construction contract, which is one of the few provisions in the construction contract that actually deals with this process, does state, and this is in the supplemental bundle, page 174, for turning to it, well, I'm sure you've seen it enough in this case already, but it does say, any decision of the liaison committee shall be final and binding unless the parties otherwise agree.
It does. And in the we have those same words in the project agreement.
we do.
Now, in the project agreement, I can see they may fulfil a purpose because although you've got the representatives on the liaison committee, it's not obvious that they would have the authority to bind their companies in the absence of some other provision. And I think I saw a moment ago that in clause 11, dealing with representatives, there's the identification of other people who are to be treated as having the authority to bind the parties themselves. And one could give some sense to that, and therefore you can then marry in the project contract both the function of resolving amicably and it being final and binding.
Absolutely.
When you come to the construction contract, you can't do that.
No.
And one of those two has to give. But it may be that you could say, well, in the construction contract, you can either ignore that or you can treat it as having some content that it will be final and binding if the parties during the process confer that authority on the liaison committee. So they may get to a stage where the liaison committee has got them together and they're agreed on pretty much everything, but they can't agree on the rate of interest. And they say, well, right, you decide the rate of interest. So one could, in the construction contract, give effect to that without in the construction contract, the liaison committee being able to impose a solution on the parties. So it would just be mediation by another name. It would be seeking to resolve it amicably.
Yes, although, of course, the reference to resolving things amicably is in fact only found in a project agreement. So one would be giving precedence as regards these two parties to words found in clause 12 of the project agreement over the express words found in schedule 26 of the construction agreement. In other words, if insofar as there is a conflict between the two, what one might think that clause 3.1 of schedule 26 should take precedence because that's actually in the construction contract. Whereas the clause 12 process from the project agreement is only incorporated via a rather circuitous route involving the definition of the liaison committee.
I understand that, but the parties to the construction contract can only have intended that the liaison committee should have the powers and the functions as defined. And the incorporation of the definition must have had at its heart that what the liaison committee was and wasn't to do was what it was identified as having the function and authority to do in the project agreement. Otherwise, one wouldn't really be importing the definition at all.
Well, we'll be coming to it in a moment, but one has the additional hurdles of Kajima obviously having no right to attend or make representations at the liaison committee procedure. And if one, in my submission, if one is to treat it as a mediation process with a non-binding outcome, one gets to the point where one is reading a very large amount into this contract in order to save a process, simply because the parties appear to have indicated that there is some process they mean to have in place here. But in fact, what one ends up with is a process that is so far divorced, in my submission, from the words used, certainly in a construction contract, but in my submission, either of the contracts, that in my submission, one could have no certainty that this really does reflect the parties' intentions. It's a very purposive interpretation to try to save it. And in my submission, going back to what I said about a party being entitled to be certain about what they need to do before commencing a legal claim, in my submission, if one is at that stage where one's having to read in these various requirements to save it, or to prevent it from having an absurd outcome, such as a partisan committee can bind Kajima simply by its own, whatever decision it should choose to take, if one is having to go down that route, in my submission, it would be more appropriate simply to find that the whole process is inadequately spelt out in the contract, and therefore not binding at all, which was, of course, the judge's conclusion. and because for the avoidance of doubt, our position is that second sentence of clause 3.1 is clear in its meaning, that the liaison committee, as defined in clause 12, is expected to produce a recommendation. That liaison committee consists solely of members of the trust and project co. There is no obligation to invite Kajima, although it is likely that that will happen, as indeed it did happen in this case. It's likely to happen, but there's no obligation. But that having procured a decision via that route, and going back to my reference to the case of Schulter and Nile, I have my doubts that the court would view that as an enforceable decision because of the bias that affects the process.
Is there any case in which a mediator has been removed from bias? It's a completely different function.
No, not that I'm aware of. But in my submission...
And of course, a decision maker who is affected by bias, actual or apparent, is objectionable. But a facilitator may not be objectionable at all.
No, and I understand that. In my submission, though, this is not as described in clause 12, once applied to the construction contract, it is not a mediation process, it is a decision-making process of that panel.
Yeah, I understand that submission. And there's just one further thing I wanted to ask you. I'm sorry to keep slowing you down.
No, please.
You say Kajima has no entitlement to take part, and there's no obligation to invite Kajima. Would the liaison committee be exercising its functions to resolve the dispute amicably without taking that step?
I think that is a difficult question. I mean, it would...
Sounds quite straightforward to me. if the function is to resolve it amicably, then they're going to need to involve the two parties. You're perfectly entitled to say no certainty or indication as to exactly how they're going to go about it and what the process is and so on. But your premise is there's no obligation or no entitlement for Kajima to be involved at all. And I wonder whether that can sit with the word amicably.
When I say it's a difficult question, I mean that, again, we're in the territory of the contract not spelling any such thing out, and one having to therefore read yet more into it in order to save the process. And in my submission, that deprives the process of the certainty which it should have in order to be an effective and enforceable alternative dispute resolution process.
If you're leaving 3.1,
Yes.
Who do you say the parties are?
I say the parties have to be the parties to this contract. I frankly, in my submission, don't entirely know what it would mean to say that a decision on a dispute between A and B shall be binding on B and C. I mean, theoretically, one can understand perhaps what that means, but it's difficult to give it a business common sense meaning.
And are the final words superfluous, unless otherwise agreed?
They are in the following sense, that Project Co, having been part of the unanimous committee reaching that decision, it is very unlikely to agree with Kajima to set aside the decision. But that is what it says. It says, Project Co and Kajima are welcome to get together and say, we don't like that decision. Let's take it to court. So
But you wouldn't need those words in order to
no, yeah, they're superfluous in the sense of any contractual term that purports to allow the parties to agree a variation is generally superfluous because the parties have that inherent right. And yes, it's superfluous in that sense.
But one can't discard the earlier part as superfluous.
Well, no, because contracts regularly contain provisions saying the parties can agree to do this, can agree to do that, and there's a difference, in my opinion, between between looking at words in a contract and saying those are superfluous because that is the default position anyway, so I can ignore them, and looking at words which are quite different from the default position and discarding those.
Thank you. I'm sorry. I've taken
No, not at all. So those are my submissions on why the outcome of this process is unenforceable. I'd like to now return to the judge's reasons for finding that the commencement and process itself were unenforceable. Those are, in the judgment, I was referring to it earlier, Core Bundle, tab 5, page 53.
So are those the other sub-paragraphs of 61?
They are. And I'm just going to jump around a little bit, take things in chronological order, so to speak, from the start of the process onwards. We have at Roman numeral 3 at the bottom of D53, just the first sentence. First, it's unclear how a dispute between CAP and Kajima should be referred to the liaison committee. That's the start of the process. And if one goes back up to Roman numeral 1, very first sentence, there's no meaningful description of the process to be followed. And then as part of that, but in my submission could be viewed as a separate point, a little over halfway down that paragraph, there's a sentence that starts, furthermore, it's about 10 lines down towards the right. And it says, furthermore, there is no obligation on the trust to play its part in any particular way. And in my submission, that in fact could be viewed as a separate point. One is that the procedure as a whole is unclear, but secondly, there's a party who needs to take part in it, who actually can't be compelled to do so.
Sorry, just the first sentence of Roman 3, unclear how dispute should be referred. So that's uncertainty as to commencement.
Yes.
Most arbitration clauses say, in the case of any dispute, it shall be referred to arbitration. It doesn't set out what has to be in the notice. I don't think any arbitration clause has been struck down as unenforceably uncertain just because it says in general terms the dispute has to be referred.
No, and I can understand that. There are indeed in a sort of slightly different sphere that I know my Lord Justice Coulson will be deeply familiar with. In construction, we have adjudications. One does often end up in quite detailed arguments about the referral notices used in adjudications and their scope and timing. But I do accept your point in arbitration that, or indeed amicable dispute resolution clauses involving simply taking it to a committee, they often are relatively brief. And so effectively the first point, unclear how referred. Second, no meaningful description of the process to be followed. Third, no obligation on the trust to play its part in any particular way. And then at point 5 is it's not clear when the process of referral to the liaison committee comes to an end such that the dispute is not, quote, not finally resolved. And I'm treating that as part of the process. I've just discussed whether the outcome of in terms of a decision is enforceable. This obviously slightly straddles the gap. It's the question of when is the process at an end. Again, we say the judge's conclusions in these regards are correct. They largely mirror similar views that I took your lordships to in the Tang case, where there was a similarly vague description. There obviously are no general rules to fall back on in terms of an arbitration body's procedure or similar. All we have to play with is clause 12. And as the judge notes, questions include how will the dispute be identified properly if the appellant is not present? Will the appellant be invited? And what if they refuse to attend? Or, perhaps most importantly, to look at it the way that it was being discussed this morning with Mr. Hargreaves. What is the minimum duty of participation that is required of each party? There's simply no clarity on that. And that is a requirement. Mr. Hargreaves accepted it's a requirement. And in my submission, it is not present in this case.
Well, I think he said the minimum duty is 0.
Well,
there's no duty to pay.
And in my submission, that highlights that this is no dispute resolution procedure at all. If one of the parties to the dispute, or both parties, need to do nothing, or perhaps need do no more than write one letter, in my submission, I query whether that is, in truth, or how that could, in fact, comply with the requirements laid out in Tang and Holloway. I don't know how a letter can get to a resolution, or nothing can get to a resolution. There needs to be a process in between to explain how you get from one to the other. And that is the process that's meant to tell the parties what their minimum duty of participation is. And in my submission, if there is no minimum duty of participation, it rather highlights that there is no process. And I just remind at this point that one of the requirements from Tang and Holloway is that there should be no need for further agreement before matters can proceed. And yet I go back to the point here that this process involves the trust, who is not party to the construction contract. They need to be convinced to do their bit. But asking rhetorically, but why would it want to spend money, public money, resolving a dispute to which it's not a party? Well, of course it will generally do its bit, but if nothing else, and I think as we've seen in this case, it will prioritise its own interests in getting its own position straight first. But I'll move to the point which, in my submission, also has the most directly turns on the wording of the contract. In my submission, the others turn on the absence of wording in the contract, but the one that turns on the wording of the contract is, when is the process at an end? And in this regard, I'd like to turn back to Schedule 26, to the construction contract, which is Supplemental Bundle, tab 6, page 174. Now, we say that this schedule states that at 3.1 that the dispute should be referred to the committee. It talks about the final and binding wording. 3.2, where a dispute is a construction dispute, the liaison committee will convene and seek to resolve the dispute within 10 business days of the referral of the dispute. We say that there is no statement that that is the conclusion of the liaison committee process. And indeed, we say, given that it is expected in the ordinary course of events, as we know from the contract, for it to take 10 days to call a meeting, it is, we'd submit, envisaged as a very real possibility that the liaison committee process will often extend beyond 10 days. And certainly in the case of non-construction disputes, that expectation is very clear from clause 4 beneath on mediation. But either way, there's simply no wording here that says that is the end of the liaison committee process. Certainly we would say that if, suppose a liaison committee met on day 15 and reached a decision, is there anything here that says that decision is not valid? It's been referred to them. They've sought to resolve the dispute within 10 days. Maybe they did meet within 10 days, but needed to have a second meeting, or maybe they didn't manage it, so had to meet on day 15. There's nothing here in my submission that says that the process comes to an end after 10 business days. 3.2 is simply stating that there is an aspiration to deal with things promptly. no doubt in partial recognition of the Housing Grants Construction and Regeneration Act, which brought to the fore the need to ensure cash flow in the construction industry and prompt resolution of disputes. That is probably why construction disputes are treated differently and why they say you should try to resolve it within 10 days, but it doesn't say that's the end of the process. And certainly we say it wouldn't. Clause 4 says that you can commence mediation in the case of a non-construction dispute, and most disputes it would be 20 days, but mediation and construction disputes it can be 10 days. So that gives you a guide as to when you may start a mediation, but there's no similar guidance for when you may start an adjudication under clause 5. And importantly, turning to clause 7, no guidance as to when you may start legal proceedings. All it says at clause 7.1 is all disputes to the extent not finally resolved pursuant to the procedures set out in the foregoing provisions of the schedule shall be referred to the High Court of Justice in England by either party for resolution. Now, the first point I would flag up is in my submission, this is why we say that commencement alone cannot be the requirement for starting legal proceedings, because the wording of this clause indicates that you can only start legal proceedings when a dispute is not finally resolved, and merely commencing something wouldn't tick that box. You'd need to have had that procedure play out and not resolve the dispute, in my submission. So we say that...
Would it be an abuse of language to describe it as not finally resolved if you commence proceedings as soon as you've referred?
I dare say it was not finally resolved even before it was referred to the liaison committee. But it is very much that wording that was relied upon at first instance to render it a condition precedent, saying actually not finally resolved means you have to go through the hoops before you start your legal proceedings.
I was wondering about that. This is the clause that the judge relies on, isn't it? To say that, or one of the clauses that she relies on to her conclusion that this is a condition precedent.
I believe it is. I'm just...
So your submission is that therefore, to the extent not finally resolved, what you say that must mean not simply commenced.
Yes. Well, we certainly say the following, that this having been deployed against us to argue for it being a condition precedent to litigation, to have complied with the preceding steps, not finally resolved can't simply mean there is a dispute out there that hasn't yet been resolved, which was true before any reference to a liaison committee might have occurred, and it would be true the day after a referral has happened, and it would continue to be true. This is in answer to my Lord Justice Popplewell's question. Well, you know, it is not finally resolved, isn't it? And yes, in one sense it is. But in my submission, when viewed in the context of this process and the arguments that were run at first instance, which were successful, effectively, if you want to say, you could say that the judge read in not finally resolved by what's just been described above. So in other words, it's not saying any dispute that's not been finally resolved. It's specifically saying a dispute which has been through the mandatory parts of the process above and hasn't yet been resolved. Hasn't been resolved even after those. Because if it didn't mean that, in my submission, the condition precedent argument would have gone a different way.
Well, I'm not sure about that, because the judge relied, I think, quite heavily on 3.1, shall first be referred, and the contrast also with particular cases in paragraph 2, which in the limited class didn't prevent you going to court first. I understood her decision, those were the principal bases on which she found it was a condition precedent. Shall first be referred, and the contrast with
Yes, and
two,
yes.
which said in those two particular cases, injunctions and summary judgment, it isn't a precondition.
And obviously, it's always, there's a line to be drawn between what's appealed, what's covered by the grounds of appeal, etc. She does say at 61.5 of her judgment at page 54 of the core bundle, it seems unlikely that referral on its own can satisfy the condition precedent.
But she doesn't engage in any process of reasoning as to why that is so.
No, so I'm just reading on through the paragraph. Yes, in fact, I think in many ways, when one reads 61.5 of her judgment in full, I think one of her central points is, in fact, that there is effectively it is uncertain what these words mean. The words "to the extent not finally resolved" in paragraph 7.1, this is the last two sentences, might be said to import an understanding that a proper opportunity will have to be given to the liaison committee to arrive at a final solution. Despite deciding when the dispute has been, quote, finally resolved, and thus when legal proceedings might be commenced, does not seem to me to be straightforward or certain. And in my submission, that is correct, and I'd adopt that. But again, the amount of argument we're having as to what this whole process means and when it starts and when it stops, in my submission, highlights the very uncertainty which we say affects the entire process.
In clause 3.1, Mr. Webb, do you attach any significance one way or the other to the wording referred for resolution?
Well, only that it might incline one towards a view that you're expecting a decision and not anything sort of a lesser stature. But
Well, might it be said if what it meant was that the condition is that there should be a resolution, it would say shall first be resolved. Whereas what it actually requires as the condition is referral, shall first be referred, albeit that the purpose of the referral is that there should be a resolution.
in my submission, if one is potentially at risk of focusing too much on the minutiae and not enough on business common sense, in my submission it would be odd, going back to the example given before, if the parties were imposing a technical requirement of this letter having been sent at least 30 minutes or 30 minutes before the claim is issued. If you're going to impose a requirement like this, in my submission, business common sense would indicate that what you're really looking to do is to have a process that plays out and thereby hopefully obviates the need for the proceedings that then follow.
Well, the process might do that. Is there anything obviously uncommercial in saying before you go to court, or in effect just before or at the same time as you go to court, you have got to trigger this process, and this is a process which is intended to aid amicable resolution outside the court proceedings. We're not saying that you've got to wait. The court proceedings can be managed depending on how the amicable process works, but you've at least got to trigger this talking shop, and that's useful and sensible because it might produce a result. We've been focusing on uncertainties and what is or isn't something that people can be forced to do. But if you don't look at it as a matter of obligation, but look at it simply at what is contemplated, it may very well be that the parties say, once they've had to start the process, that they can't just ignore it. Okay, we've had to start this process. Now, the sensible thing is that we'll invite Kajima along, we'll have various meetings. It may need to take 2 months. It may result in a recommendation that we're happy with. We're not bound to accept it, but it may be a useful process. Now, that's not uncommercial, is it?
I would say 3 things. First of all, it's just a matter of overall impression, but in my submission, it would be very far from standard. I don't think in my submission, not seen a dispute resolution clause.
I wouldn't disagree with that.
That ilk. As to why, well, I might
it could be
suggest
said that this is the sort of language you're looking at is very standard.
no, yeah, one might say that it's far from the only part of this contract one has not seen before, but I'd say the second point maybe that answers that first question, why? Well, because the parties would be potentially throwing away one of the major benefits of having a process like this, which is the opportunity to avoid incurring the costs of the proceedings that follow. But what I would say is point 3 is, if that is correct, if that is what it means, then it simply highlights the inconsequential nature of the complaint made in this case, because all that has happened is that the suggestion that we go to the liaison committee has been made in letters around the time that the claim was started, but never formally sent off, and then formally sent off a few months later with a stay being sought. So if that is the intention, then it just further emphasises that the actions of the respondent here give effect to the intentions of this clause, even if there were, on that interpretation, a technical breach. So I would say if that were the intention, it would just highlight that the exercise of discretion should be in favour of the respondent.
Well, if the intention of the clause is you can't start proceedings unless you've committed yourself to this process, your clients haven't. The fact that they've done it later is not what the bargain is, if this is the bargain, obviously, which is...
Yes, and it's a point I'll come to later, but of course, nearly all applications under... a lot of applications that come to the courts under, for example, 3.4 of the CPR for strikeout or other matters, or relief from sanctions, or CPR Part 11, they are about parties who have not abided by something, a contractual requirement, a provision of the court rules, some other, a court order. That in and of itself doesn't necessarily mean that much. The question then is, how should the court tackle that person in accordance with the overriding objective and fairness and reasonableness and proportionality? And I would say that if all that can be said is the letter was sent a couple of months after instead of a week before, I would say, well, yes, as in all these other cases, there may be a technical breach, but when looking for a proportionate response to it, it would absolutely be a stay. But just to finish on this point, to highlight a point I've made a number of times, in many ways, the length of these discussions, the difficulty in getting a clear answer on them. In my submission, and as is clear from the judge's reasoning in 61.5, they're all reasons for finding this procedure to be unenforceable because of the amount of work that has to be done to identify what it means. Those are my submissions on ground 1, which obviously the enforceability of the provisions. Ground 2 will obviously be swift. It's a relatively short point. This relates to whether a stay is a default remedy. And my 2 points here are, 1, that the judge was correct in what she said, and secondly, that the ground is irrelevant in any event. On the question of whether the judge was correct, Mr. Hargreaves took your lordships to the IMS and Capital Oil case, the decision of Lord Justice Popplewell in the High Court, where there was this distinction drawn between the usual remedy for effectively a defective service type complaint versus the normal remedy for what was described as a forum non conveniens type case. And it's correct that this isn't strictly the latter type of case, but in my submission, again, at risk of being told that was not what was intended, in my submission, it's more about the distinction between a jurisdictional attack under CPR 11.1a, which is where the allegation is that the court does not have jurisdiction, and 11.1b, where it's said that the court should not exercise its jurisdiction, and that in practice it is the cases where the claim has simply been started wrongly, where the normal remedy is to set aside the claim form because effectively it is a nullity, and that where it's been started correctly, but the court is being asked not to exercise its jurisdiction, where a stay is the normal remedy. So firstly, I rely on that case and that statement. But secondly, I also rely, again, not wanting to be accused overly of playing to my audience, to the case of DGT and Qubit, which was a case that Lord Justice Coulson was in again at High Court. And in this instance, I rely not upon anything said in the case, but rather the fact that it summarises a variety of authorities on this topic. It's at tab 8 of the authorities bundle. And on page 134 of the report, and this was an application to stay court proceedings pending compliance with a mandatory adjudication provision. And there is, starting at paragraph 5, a review of a variety of authorities on the point. And at paragraph 5, there's a description of Channel Tunnel Group Limited and Balfour Beatty, and one sees from the quote at point G from Lord Mustill, nevertheless, I'm satisfied that this is the correct route and that the court not only possesses the discretion to grant a stay, such as the present, but also this is a remedy which ought to be exercised in the present case. Over the page at point 6, one gets another case started in breach of a dispute resolution clause, Cotton Barber, and again a stay granted there. That's referred to at the end of that paragraph. The next paragraph, paragraph 7, the case of Cape Durasteel and Rosser and Russell, and again the last sentence, it was appropriate to order that the action be stayed. Paragraph 8 is in fact a different separate point about someone seeking an injunction that was not granted, and then point 9, Cable and Wireless versus IBM, and again the last sentence, a stay was therefore granted in respect of the court proceedings that had been started in breach of the ADR agreement. And on top of that, one adds this case, DGT and Qubit itself, and the OPEN case that is at tab 13 of the authorities bundle, another case where a stay was granted. And we say that all of these cases show that in the instance of a party starting proceedings that has not complied with a mandatory dispute resolution provision, the default remedy is and has always been a stay. Now, that is not to say that, of course, a party in Mr. Hargreaves' position can't say, well, this case is different, this case is different. Yes, that's the whole premise of the argument here. But in terms of an actual attack on something the judge has said to try and clarify the law, that a stay is a default remedy, in my submission, she was quite right to do so. And it is in this instance also material that at first instance and on appeal, the only case either of the parties could find where there was a strikeout or setting aside of a claim form or similar was Snooks. So that's the one case that the parties have been able to track down where an equivalent outcome to this eventuated. So we say it's right that the judge made a clear statement saying that this is the default remedy. The law functions by judges giving guidance of things being the default remedy or that some appropriate relief is usually the case. And the judge was right to describe it in those terms. But in any event, the second point is that this ground is not relevant in any event. it is asserted by the appellant that this view somehow constrained the judge's discretion. But in my submission, that's not right for two reasons. Firstly, it's not the meaning of the word default. A default is something that you fall back on in the absence of any factors pointing in one direction or the other. It does not constrain a decision maker. It is simply a fallback position. And we've seen in this case that the judge fully reasons how she gets to where she gets to. She doesn't rely on the default position. She does not fall back on it. The reasons are given at paragraph 88 of her judgment. But secondly, I'd also like to take your lordships to part of the judgment that was quoted by Mr. Hargreaves, and it is paragraph 85 of the judgment. It starts on page 58 of the core bundle. And Mr. Hargreaves read out, I agree with Mr. Webb that it would be difficult to extend snoops into cases involving a failure to comply with a mandatory ADR provision without cutting across the guidance given in the cases to which I have referred, which demonstrate that a stay is the appropriate or default remedy. And she says, however, I see no reason why in a case which engages CPR 11(1)b, the court could not determine that a different form of relief was appropriate having regard to the particular facts. Now that's a material qualification on what was said. And then when combined with paragraph 88, where she goes in detail through the facts and sets out her reasoning, and does not fall back on this notion of the default, in my submission, there's no reason to think that there was any impact on her reasoning of setting out that that's what she understood the default position to be. This is further emphasised by the reasons for refusing permission to appeal, which she gave, which the relevant page of which can be found in the core bundle at page 68. And in the box at the top of page 68, there's a line that begins ground 2. And she says ground 2 is irrelevant to the outcome. So she didn't think that she was influenced by it. In my submission, the judgment doesn't indicate that she was influenced by it. And therefore, ground 2 does not, in my submission, assist matters. So I'll move on to ground 3. My argument on ground 3 is as follows. First point, this is a challenge to a first instance judge's case management decision, and therefore faces a high threshold to succeed. The appellant's attempts to dress it up as more than that are flawed. The judge did consider all the matters she is alleged not to have considered, and she was correct to take into account all the factors which the appellant says were irrelevant. Accordingly, the high threshold remains, and not only is the threshold not passed, but in fact the judge was entirely correct in her exercise of discretion in this case. So I will start with the first point, that this is effectively a case management decision of the judge. Just a brief bit of history here might help explain some things and put things in context. As you're probably aware, this application at first instance was made on 4 legal bases. It was made under both limbs of CPR 11(1), namely that there was no jurisdiction to try the claim. That's limb A, or B, that the court should not exercise its its jurisdiction if it did exist. It was also brought as an abuse of process allegation under 3.42a, strikeout under 3.42a, namely on there being no reasonable grounds for bringing the claim, and also on 3.42b, an abuse of process. Now, on the basis of the grounds of appeal, it is only the second of those, 11.1b, that the court should not exercise its jurisdiction. That is retained on this appeal. However, we say that this doesn't fundamentally alter the nature of the court's task in terms of the questions which it must ask itself and the balances it must weigh. And in that regard, I refer to the case of Cable and Liverpool Victoria, which is at tab 3 of the authorities, sorry, not tab 3, tab 5 of the authorities bundle. And if I may I'm going to start towards the end of the judgment and then slightly work back, because I think it's the point at the end that gives what's earlier that's most useful context. On page 11 of the judgment, the numbers are in the bottom of the page, paragraph 62. So just to put the case in context, what had happened in this matter was that a claimant had started following the road traffic accident RTA protocol on a potential claim, and the defendant had admitted liability. Rather than continue with stage 2 of the protocol and discuss quantum, the claimant had delayed until the quantum had grown so large that the RTA protocol no longer applied. And what it had then done is issued the claim under Part 8 and sought a stay to comply with the protocol. The proceedings were stayed, and then it realised the protocol could no longer apply, so it applied to lift the stay and transfer the matter to Part 7. And the defendant cross-applied to keep the stay in place and strike out the claim. And this paragraph emphasises that effectively, however one dresses things up, and whether it's a stay or not, ultimately what we're dealing with is having to grapple with the issues of abuse of process. It says, I'll pick it up from the line 5 on the right, there's a sentence starting but since it's accepted that the proceedings cannot remain in a sort of legal limbo, this approach, which is sort of issuing a stay and leaving it there, this approach presents the striking out as an act of kindness, putting useless proceedings out of their misery. I consider that such an approach puts the issues the wrong way round. If the defendant is seeking to prevent a valid claim from going further, then no matter what the mechanism by which that debate comes before the court must grapple with the central dispute. Should the claim be allowed to proceed, or should it be struck out? That issue will be informed, but not decided, by the answer to the prior question, has there been an abuse of process? And in my submission, that's quite right and applicable in this case. It doesn't matter that it's on paper an application under CPR Part 11. The fundamental point that has to be wrestled with is whether this claim ought to be allowed to go further or not. And the court properly should recognise that has the effect, in whether one describes it that way or not, of striking out the claim, and consider the points that I'm about to refer your lordships to earlier in the judgment about the ramifications of that and the way to approach it. So if I can turn now to earlier in the judgment, on page 8, paragraphs 43 and 44. Paragraph 43 has a working definition of abuse of process, a use of the court process for a purpose or in a way which is significantly different from the ordinary and proper use of the court process. and I would emphasise there the word significantly. And paragraph 45 says a claim must be clearly shown to be an abuse before it can be struck out. The striking out of a claim is a draconian remedy and one that should be seen as a last resort. And I emphasise both from paragraph 62 of this case that I took you to a moment ago and as a matter of common sense, if what's being said is that a valid claim form should be set aside, in my submission that is materially the same as seeking a strikeout. And I also just turn to paragraph 47 over the page for one final note. This court's reluctance to countenance striking out the claim, save as a last resort, can be seen in Alpha Rock Solicitors and Allied. The claim was originally struck out as an abuse of process because it relied on false and deliberately exaggerated claims and fabricated documents. The Court of Appeal concluded that there had been an abuse of process but reversed the striking out order. And I note in the quote below from Lord Justice Voss, on the fourth line, a sentence beginning with but it must be remembered that the remedy should be proportionate to the abuse. I pause briefly to note a claim not struck out for being false, deliberately exaggerated claims and using fabricated documents. And here we are dealing with a party that thought it better to fulfil the dispute resolution clause when it knew how much money was being claimed, rather than, sorry, after it knew how much money was being claimed, not before, and sought a stay to make sure that could happen. In my submission, a world apart. And indeed, to flag up a point I made in my skeleton argument but haven't yet repeated orally, but my submission is important. The judge herself described this at paragraph 89 of the judgment as an entirely sensible approach that was adopted by the claimant, the respondent, in these proceedings. So that's my first submission as to the threshold that is applicable to this case. My second point relates to the role of this court in reconsidering the judgment of a first instance judge on a strikeout application. The case I'd like to refer to here is the case of Abdullah, which is at tab 4 of the authorities bundle. In this case, and the breaches for reference are referred to at the bottom of paragraph 14 of the judgment, the first instance judge had refused to strike a claim out on the basis of a failure to comply with certain rules. Those involved a failure to pay a court fee, a failure to file a pre-action checklist, and a failure to prepare trial bundles. And if one can turn to paragraphs 24 and 25 of the judgment, this is when one gets to the crux of the decision. And Lord Justice Lewison says, let me say at once, if I had been the first instance judge, I would have accepted Mr. Thomas's submission, which is that it should be struck out because of, amongst other things, the impact on the trial date. I would have given more weight to the lamentable history of delay in progressing this case, etc., etc. But that is not the question for the appeal court. Paragraph 25. Mr. Thomas's submissions did not include a submission that the judge overlooked any relevant factor, or that he took into account irrelevant factors, nor did he suggest that the judge misdirected himself in law. Rather, his submissions were directed to the weight that the judge attributed to the various factors that he did take into account in exercising his discretion. That is not a promising start to an attack on an exercise of discretion. What it amounts to is a submission that the judge's decision was perverse. And then the last sentence, 2 sentences of paragraph 28, starting 4 lines down, just re-emphasise this. As I have said, I would have found that the balance tipped the other way, but that is precisely because in cases where the balance is a fine one, reasonable people can disagree. it is impossible to characterise the judge's decision as perverse. We say that that is the threshold test that applies here. It applies to a strikeout application just as much as a more run-of-the-mill case management decision, Abdullah itself being just such an application. So I turn then to the second of the points I made in my line of reasoning at the start, which is that the appellant's attempts to take this outside Abdullah by referring to the judge having failed to take into account certain matters or taken into account irrelevant matters are all wrong. Now, when it comes to the first of those points, the failure to take into account relevant matters, I must admit to somewhat struggling. And the reason I struggle is set out in my skeleton argument, which is in the core bundle at page 15. The core bundle at page 183. So, Mr. Hargreaves, in his skeleton argument at paragraph 24, lists the reasons why the things he says the judge failed to take into account. And in this paragraph 78, I go through them and say that she did, and give references to the paragraphs where she did take them into account. I look slightly at the clock and the fact that it's just a bit of a back and forth point. I don't intend to take your lordship to each of these. I don't know that Mr. Hargreaves quite went through it in that level of detail either. I'm just going to flag up one point because I think it was the point that Mr. Hargreaves majored on the most, which is this assertion that, in fact, I'll take his own words for it from paragraph 24 of the skeleton argument. So this is page 155 of the core bundle from Mr. Hargreaves' skeleton, a factor that the judge is said not to have taken into account. Although she weighed the effect of making an order setting aside the claim form, in particular the claim on the respondent, the learned judge failed to give any or sufficient weight to the effect of not making such an order on the appellants who have been deprived of a limitation defence. And I think it's fair to say that was the point that Mr. Hargreaves emphasised most in his oral submissions too. Now I just pause briefly here to flag up there is a material difference between failing to give any weight or failing to give sufficient weight. If she failed to give any weight, then Mr. Hargreaves may be able to squeeze in through Abdullah and say I don't fall within the general rule of Abdullah. But if it's merely complained that she didn't give sufficient weight, then we aren't in the territory of the judge failing to take into account a factor. We are firmly in the territory of the judge not having given it in his submission the correct weight. And I flagged that particular point up, both because Mr. Hargreaves emphasised it the most, but also because it is apparent from the judgment that the judge was entirely cognizant of this as being a central feature. Indeed, it was such a central feature that she referred to it in paragraph 1 of the judgment. At page 38 of the core bundle. Page 38, paragraph 1. This is a novel application by the defendants to strike out or set aside a claim form on grounds of failure to comply with a contractual ADR provision, said by Kajima to be a condition precedent to the commencement of proceedings. The real significance of the Kajima application lies in the fact that the limitation period for the claim by the claimant, as extended pursuant to a series of standstill agreements, expired on 29th of December, just over a week after issue of the claim form. Kajima contend that by initiating these proceedings on the 21st of December, CAP has deprived it of a limitation defence that would have been available had CAP complied with its contractual obligations. So not only was the judge cognizant of it, but she was aware that it was the central defining point of this case, so much so that she put it in paragraph 1 of her judgment. So in my submission, that is one example. The rest can be gleaned from my skeleton argument, but just it is apparent in my submission that all the factors that the judges said not to have taken into account were in fact taken into account, and in fact are very readily identifiable, invariably in the other cases, within the lengthy paragraph 88 of the judgment where she gives her reasoning. Mr. Hargreaves's reverse submission is that the judge took into account irrelevant matters. Those irrelevant matters are listed at paragraph 25 of his skeleton argument, at page 1, starting at page 155. And paragraph 88 of the judge's judgment is the paragraph where she sets out over 2 or 3 pages all sort of a chronology mixed in with reasoning of why she has decided the correct resolution would not be to satisfy the claim form in any event. And you'll see here that Mr. Hargreaves attacks, in paragraph 25, paragraphs 1, subparagraphs 1, 2, 3, 4, 5, 6, 7 and 8. So effectively, the assertion is that everything the judge considered, she was wrong to consider. Now, I'll just briefly take these paragraphs in turn and just explain the respondent's position on each of them. First one is 25A. We say the judge was right, and that it was relevant that any referral of the dispute prior to commencement of proceedings would have been without the benefit of a known quantum figure. That was one of the judge's reasonings for thinking that the respondent's course of conduct was sensible. As I've already submitted, it was sensible. The dispute resolution process was going to be more beneficial if the parties had a figure to go on when entering their negotiations or discussions or decisions. 25B, it said discussions between the parties or lack of them is irrelevant. Now the discussions being referred to are the ones I referred to shortly before lunch, that the initial request to delay negotiations came from Kajima. We say it is relevant that negotiations were paused at Kajima's request, and that this accounts for much of the time between discovery of the defects and commencement of the claim, and that despite having asked for negotiations to pause until the remedial works were complete, standstill agreements were then terminated beforehand. We say that if there are 4 factors that would be material to any exercise of discretion, it's the conduct of the appellant, the conduct of the respondent, the prejudice to the appellant, and the prejudice to the respondent. And this goes to the conduct of the parties as to how they got into the situation they're in.
Mr. Webber, I don't want to put you under any pressure, particularly since we've collectively asked you a good many questions, but I'm conscious of the time. There's still a bit of ground to cover, and of course Mr. Hargreaves will want to have some time to reply.
Yes, and I am aware of that. I think at the moment the risk is that I go up to past, but not beyond. I understand that would be then taking us up to the formal end of day. I'll try to speed up as much as I can. I'm at the moment very hopeful that I won't myself go beyond, but I do understand that would push Mr. Hargreaves beyond, but I will do what I can. I mean,
I mean, the short point is that each of the items in paragraph 25 that you say, that Mr. Hargreaves says is irrelevant, you say are relevant.
yes, my lord, and that I was in fact probably about to short circuit that way, so I'm grateful. The short answer is that they all ultimately go to the conduct of one or other of the parties, or the prejudice to one or other of the parties. Those are all material factors, and that in fact what Mr. Hargreaves is asking the court to do is to say that this exercise of court discretion should in fact ignore vast swathes of how the parties got to be where they are and what the parties were intending to do by their actions, and effectively focus almost to the detriment of all other things on his assertion that he's lost a limitation defence. And we say that's not right. The judge was in fact correct to view her discretion as being very broad. So we say that it would be wrong to hold that the judge was incorrect to have taken into account any of those points, and that as a result there is a high threshold to be overcome by the appellant in overturning the judge's decision on this. And in any event, we say that the judge's decision was right, and I will just speed through those reasons which broadly mirror those given by the judge. As I've already identified, the respondent was not a party looking to ignore its alternative dispute resolution obligations if they were enforceable. It had engaged with Kajima through the liaison committee to get the remedial works done, and it wanted to do so about the deductions. It was only a question of when that happened, but it was definitely wanting to do it. It isn't a case of a party just ignoring those requirements. As I say, the reason it had not referred this matter before is because the trust had not said how much it was claiming yet. Third, the alternative dispute resolution procedure to which it would have had to be referred is, in my submission, unique, and depending upon how one construes it, in our submission produces a perverse outcome of a partisan committee producing a decision that is final and binding on the appellant. That would be patently unfair and of very little value, and we say that therefore the ADR process that it is said should have been followed is of little utility. The prejudice to the claimant of not permitting this claim to proceed would be very large because it would lose the entire claim. The prejudice to the defendant of permitting the claim to proceed is limited. It is proposed that the parties still go through the liaison committee process if it is found to be enforceable, and when that is done, the parties are effectively in the position that Mr. Hargreaves say they should have been in, which is early stages of litigation after that process. The defendant's assertion of real prejudice is premised upon losing a limitation defence. But the only contractual promise, if there was one, assuming against me, the only contractual promise he points to was that there should be a referral to the liaison committee before proceedings were started. So that is what it has been deprived of, a referral to the liaison committee, not a limitation defence. It's been deprived of the referral. You can only say it's been deprived of a limitation defence if you know how, in a hypothetical world, things would have played out if there had been a decision to refer it to liaison committee first. And in my submission, given the content of the respondent's letters throughout December, it's apparent that if the decision had been taken to refer it to the liaison committee first, that would have all been done in good time because the respondent was acutely aware of the final deadline for litigation. So in my submission, the proper understanding on these facts is that Mr. Hargreaves has not been deprived of a limitation defence. He's simply been deprived of a referral to the liaison committee first. The claimant's approach that I've already indicated ties in with that which is explicitly endorsed in similar circumstances in the pre-action protocol for construction and engineering disputes. it is also, in my submission, a process which most respects the goals of alternative dispute resolution, which is that it is decision taken to pause it until it can be of use because the quantum is known, rather than to treat it merely as a box to tick before you can get yourself into court. And finally, and a matter which this court may be more concerned about possibly than first instance, but is more generally relevant, as a point of public policy, one can see that if court users see draconian sanctions for failing to comply with alternative dispute resolution provisions near limitation, then they will pore over their contracts for minor inconsistencies between what has happened and what should have happened, and that those inconsistencies, rather than being resolved by sensible agreement, will lead to the parties digging their heels in because so much will be on the line. My submission, you've seen the cases that generally lead to stay in these circumstances.
I mean, parties will seek to insist on their contractual bargains.
My lord, as I've mentioned before, one can put it that way, and one can often say you've breached a court order, you've done this, you've done that, you've done the other. The question in my submission is how the courts react to that proportionately and in a way which is in accordance with the overriding objective. And in my submission, that the current situation where one commonly sees stays leads to sensible reconciliation between the parties who talk before the first CMC or pleadings are in, who work out what they need to do before they get to that case management conference, who go through the various requirements of the contract in the proper manner and in good time. In my submission, it would not be a positive movement to replace that with a technical approach where there is a huge amount on the line and therefore minor points are being developed into major obstacles. And I've been through the factors that go to the exercise of discretion, but I do loop back to the case of Cable and Liverpool Victoria that I referred to earlier, and the need for a proportionate response. And in my submission, where the complaint is a failure to engage in a dispute resolution process, the proportionate response is nearly always to stay matters so that the parties can make that good. And in my submission, a remedy that effectively strikes the claim out, sets aside the claim form, would go well beyond that. My lords, 5 minutes on the cross appeal. This is the point about the parent company guarantee. I think you will no doubt know points. I know some of them have been echoed. The parent company guarantee is at tab 7. And the two key clauses are 2.1 and 2.4. I cannot recall whether your ownerships were taken to 2.4 during the course of Mr. Hargreaves' submissions, but if either way, I'd like to emphasise it because it is important. It's on page 185. So you've been taken to 2.1, but that has to be read in light of 2.4. The guarantee given by the primary guarantor shall be a primary obligation, and accordingly, Project Co shall not be obliged before enforcing this guarantee to take any action in any court or arbitral proceedings against the contractor, to make any claim or any demand of the contractor, etc., etc., etc. We say that is, insofar as clause 2.1 can't in fact be understood to prevent Mr. Hargreaves' argument in any event, we say 2.4 is the answer. But just taking the points in turn, your lordships focused during questioning of Mr. Hargreaves on this word liability, and in my submission you were right to focus on liability. The fact is that if the claim form as against D1 is set aside, it doesn't mean that D1 ceases to be liable. it simply means that no claim is being pursued against D1. It may have been, but it's now a historic fact it ceases to be pursued. One doesn't even need to consider the existence of a limitation defence because the claim isn't going to be started again against limitation. D1 will just cease to play any part. All we'll be left with is a claim against D2. Is that a problem? No. In fact, 2.4 is quite express. We are entitled to bring a claim solely against D2. So it is unclear why, by succeeding on a procedural point that has no bearing whatsoever on its liability, it's entirely unclear as to how that gives rise to any defence to the claim that would affect the claim against D2. And that is because the effect of setting aside the claim form is not to reduce the liability. The same is true of a limitation defence. As noted, it does not affect a party's liability. It simply bars the remedy, as has already been noted. But I'd also emphasise again that clause 2.4 helps me on that, because it would be perverse if we didn't have to start proceedings against D1. We chose not to. We only started them against D2. And then, halfway through those proceedings, a limitation defence becomes available to D2 because we didn't start against D1 and that claim would now be time barred. In my submission, it just doesn't work. If you don't have to start a claim against D1, then it can't be the case that limitation defences available to D1 can be deployed by D2. It would just be of no business common sense. So we say both as a matter of interpretation of the contract, the word liability, and as a matter of common sense when looking at 2.4 and the fact there is no obligation to bring a claim against D1 at all, there is no basis upon which D2 can rely upon the setting aside of a claim form against D1 to defend its claim. And the final point I'll turn to, cognizant of the time, is simply the pleading point that was raised. Firstly, I'd say Mr. Hargreaves said, well, the pleader's initial reaction is right. Well, I don't actually know what that initial reaction is, in the sense that the clause 2.1 says the guarantor shall be liable to the extent of the the contractor's liability. So it's pleaded as saying, if they're liable, then you're also liable. And that's where we get to my Lord Justice Popplewell's suggestion. Is the real issue here simply the use of the word found? Well, if that is the only criticism, then, well, yes, it could easily be deleted. This is the first time that this particular pleading point has been raised as being somehow enlightening. But if that were the problem, it could be deleted. But in my submission, it's pretty obvious what's being said, which is what's being said is, if the court agrees with everything we've said so far in this pleading, as against D1, then it follows that we've also got a good claim against D2. That's all that paragraph is saying. And even if the claim against D1 were set aside, that is still what the pleading would say, save that with D1 no longer being in the proceedings, one might delete the word found, which simply carries with it an implication that there will be a finding in respect of liability first. But in my submission, that pleading point adds nothing. All it does is say...
Well, that's not uncommon in a claim under a guarantee. In the construction industry, D1 goes bust. D2 is the guarantor, but you have to work out what D1, the claim against D1 is, in order to work out what D2 owes.
Yes, and this is how you'd plead it, and you'd say that if they're found to be liable, then you are also liable. And as I say, the word found was probably used in expectation that both parties would be in the room, but if that is the real problem, then it's easily resolved. But in my submission, it doesn't go to the meaning of the contract. My Lords, I'm wary that I've probably overstayed my welcome a little bit, so I'm grateful for that, unless I can assist you further.
Thank you very much.
Thank you very much.
Mr. Hargreaves.
Well, I do have a few things to say in reply. I will. Your Lordships are by now very familiar with the issues. In particular, it's been possible to ascertain from interventions which that really most of the points are now very fully on board. And so really my reply will be short, pithy, and I hope to the point without repeating myself. First point, submit and agree that the difficulty presented by clause 3.1, the sentence final and binding unless the parties otherwise agree, is perfectly possible to be construed, as it were, away from causing any difficulties, whether that's by making a determination as to who the parties are, or whether by saying it's repugnant to the clause in clause 12 of the project agreement, that recommendations are to be made and that means are to be provided of resolving disputes amicably. So that last sentence of clause 3.1 is something that can be disposed of by construction, and in any event, I remind the court that my submission about that was that it, in any event, has nothing to do with the procedure being enforceable. That's something that comes up on another day. If somebody says, well, hang on a minute, I've got a decision here which I now want to say is binding. We also agree and advance the proposition that it is possible that the condition precedent only requires commencement. I dealt with that clumsily, and my Lord Justice Popplewell dealt with it neatly. But in the event, and in the end, I don't think our position differs very much from the question which my Lord Justice Popplewell was asking. It's simply that in order to arrive at a construction of these difficult provisions that gives them life rather than extinguishes their life, then the key provision is to convene and seek to resolve the dispute in the special case of construction disputes within 10 days of the referral. That's the construction that the authorities, by encouraging the courts to keep the clauses alive, that's the appropriate construction. Now, one can call that commencement only as a mode of analysis, or one can say, at all events, once the 10 days have expired, you can commence litigation. My Lord Justice Holroyde asked whether it would be sufficient to write a letter and then 30 minutes later begin proceedings. The answer to that is no, for several reasons. First of all, the 10 days must elapse, and secondly, because there is an obligation which was identified by my learned friend in the construction contract, which is at provider 4 of the supplemental bundle, which my Lord Justice Popplewell commented upon, that the contractor, that is to say my client, shall provide such assistance as is reasonably necessary to assist Project Co in the performance by Project Co of its obligations under the project agreement in respect of works relating matters considered by the liaison. And that also, as it turns out, answers another question which was posed, which is what is Kajima's minimum requirement of participation, which, as I submitted first time round, is 0. But if it's not 0, it's that obligation which is found in 12.1 of the construction contract.
Sorry, I'm not following that. It's my fault. The contractor that's to say Kajima has to provide assistance. This is page 135.
Yeah.
To assist CAP in the performance by CAP
Yeah.
its obligations under the project agreement.
Yes.
How does that have any bearing on the conduct of the dispute resolution in the construction contract?
Well, only that, again, in a practical sense, once the matter is referred to the liaison committee, Project Co has certain obligations in relation to what happens to it. And this clause obliges Kajima to assist Project Co with discharging those obligations.
Obligations under the project agreement. What obligations under the project agreement are engaged in this process? It's only got to assist CAP in the performance by CAP of CAP's obligations under the project agreement.
Yes, in relation to the liaison committee.
Right.
Yes, and so
And what are GAP's obligations under the project agreement, which
well,
are engaged by a dispute resolution under the construction contract?
oh, well, simply that it's referred to the liaison committee, which is itself a creature of the project agreement, so that if there is a dispute between CAP and Kajima, which is referred by one or other of them to the liaison committee, then that engages the project agreement liaison committee, which is what it's defined as in the construction contract. Project Co has its obligations on that committee, and Kajima is to assist it with discharging its obligations in that respect. My own friend made submissions essentially to diminish the situation and to say that really it's what's happened is a technicality, and also when making submissions on discretion, he said that a response to the situation should be proportionate. And as did the judge below, so did my learned friend, spread wide the net of facts that one looks at in terms of exercising that discretion. We entirely disagree, respectfully, with that approach. What happened was a clear and plain and inexcusable and not so far excused breach of a condition precedent. If such a point arises, my client is entitled to take that point. Parties are bound by their contract. They signed up to the terms that they signed up to. It is not a small thing. It is not a technical detail. It is a failure to observe a condition precedent. And as we have said, the response is what we agree is a different question. It is simply this. Does the claimant lose its claim? Does the defendant lose its limitation defence? And there is a loss of a limitation defence here. I dealt with this as I went through my own submissions. There came a point in time where Project Co did not refer the matter to the liaison committee, thereby making it inevitable, if it then did comply with its obligation, as it ought to have done, that any claim which it then issued, having so complied, would be time barred. So there, respectfully, there is no doubt that we are deprived here of a time barred defence. I referred to it being inexcusable and unexplained. No new information came when the claim advanced in the particulars of claim was pleaded. No new information had arrived either when on the 18th of March the matter was referred to the liaison committee. It could have been referred to the liaison committee at any point since 2019, because that wouldn't be a breach of the standstill agreement. It could have been referred when we gave notice on the 30th of November. It could have been referred when we warned on the 10th of December we're reserving our position on steps you may need to take before you commence proceedings. It was also said that in Tang, at paragraph 63, a host of complaints were made by the judge in that case, many of which he upheld in the event. And my own friend said, well, all of those complaints can apply to the dispute resolution procedures in this case. Not so. The great difference in this case is simply that clause 12 goes through in the project agreement in some detail, explaining precisely what the role of the liaison committee is, and above all else, so far as we're concerned at least, it is to provide a means of resolving disputes or disagreements between the parties amicably, and it enables and empowers the members of the liaison committee to adopt such procedures and practices for the conduct of the activities as they consider appropriate. So all of the gaps that are said to exist in the procedure are not gaps at all. They can be filled in by that perfectly sensible and in a practical world, perfectly amenable and capable of being utilised, long subphrase, process. There's been also a great deal of pessimism in reference to partisanship in relation to the liaison committee. There's no reason at all why one should suppose that that's the position. These will be people who are doing their best to resolve disputes between them, which is in the interests of all of the parties. Particularly, and my Lord Justice Popplewell is right, that for the most part, Project Co, and in particular being an SPV, all it's interested in doing is passing things up and down the line. Ideally, it wouldn't be involved in any of the disputes at all. And so in those circumstances, the suggestion is very depressing, very pessimistic. The suggestion that, oh, it won't work and no good will come of it and it's all lack of utility, respectfully, is too gloomy. And since it is inevitable, in all reasonableness, that Kajima will be invited to come along in any dispute involving Kajima, if one assumes that the liaison committee has an intention of complying with its obligations, well, then there's no need at all to think that the process will be so gloomy and partisan. And my Lord Justice Coulson asked, and my learned friend touched on this in his submission by adopting, in a sense, the question. He said, and this is my last point, my learned friend says that issues as to utility must go to discretion. Respectfully.
Well, yes, if he's wrong on ground one. I mean,
if wrong on ground one?
Yeah, his submissions were utility goes to ground one, but if he's wrong about that, says it comes back in again.
It does. Of course, it doesn't go to ground one. Ground one is a question of enforceability. That's already been dealt with. It does not go to the exercise of discretion. Why should it? The parties have contracted for what they have contracted for, and on this version of events, this court will have upheld what they have agreed to do as being enforceable. Now, it would be a rum thing to then say, oh, go behind that and say, well, okay, it may be enforceable, but it doesn't look much use to us, and say, therefore, we'll utilise that as part of our discretion in order to keep the claimant's claim alive. So no, we say that utility does not come into it. Instead, I don't want to repeat myself, but it really simply is, does the claim continue, or is my client deprived of a limitation defence?
So in your case, utility is irrelevant to both grounds.
Yes.
So even if we concluded this is the most useless ADR system ever invented, we still strike out a £14 million claim.
My lord, well, we will never get
That's
there.
capable of a yes or no answer.
Well, the way your lordship puts it is, makes me reluctant to give your lordship.
I can understand that.
Can I simply say this with 10 seconds left? It's wrong to suppose that this is the most useless dispute resolution procedure to be found. Once it's accepted that Kajima must inevitably be invited to the meeting, then everything else falls away. And we've seen that the parties have been utilising the liaison committee during this project, and no doubt if they need to, they'll continue to do so. So, my lords, unless there are any further questions, that's my reply.
Thank you very much. We'll just rise very briefly just to think about next steps.
Thank you. No, I don't.
I know, that's
But mine was even older. My next best part of 80 years. They're coming back in. Oh, sorry. Yeah. Yeah. Sorry.
Mr. Hargreaves, Mr. Webb, we're very grateful to both of you for your oral submissions, and to you and all those working with you for the written submissions and the preparation of the case. Unsurprisingly, we will reserve judgment. We think, unless either of you can remind us of anything else, we think there's just one topic on which either or both of you might want to make brief written submissions. That's Cecil and Byatt.
Yes. We've given a previous.
If you do want to say anything about that, could you please each put in a short note by close of play tomorrow? Does
Yeah.
that cause any impossible?
No, not at all.
And if either of you decides that there's nothing to be said, perhaps a nil return would be helpful.
Lord, yes, thank you.
And could those responses please go to the clerk to my Lord Justice Coulson?
Yes.
And similarly, could he please be provided with a list from each of you of persons whom you suggest should receive a copy of the draft judgment, which will or judgments which will in due course be circulated, as usual, for correction of typographical errors and obvious other errors, not for further argument. And we will aim in due course to hand down judgment remotely, so when the draft judgment is circulated, we'd be grateful also for you to endeavour to agree a draft order. In default of agreement, written submissions on any outstanding topic, which we'll hope to resolve in writing. Does that cover everything?
Lord, yes, it does. Thank you.
No indication, I'm afraid, can be given about the timetable for all that. So, Mr. Webb, you'll have to wait to see whether in the final judgment the magic letters do or don't appear. But in any event, prospective congratulations.
Thank you, my lord. Do take your time.
Thank you all.